Good afternoon, everybody, and thank you very much to Matt for the invitation to speak. It's a huge honour and slightly daunting. And thank you also to Roxana for stepping in at such short notice after what Matt assures me isn't the Assize's plague. It seems the pneumonia seems to be working its way around anybody involved, so hopefully we'll all emerge unscathed from this afternoon. My topic is the limitations of the loss of self-control. And this is obviously a topic with a long history around what was the provocation defence and has subsequently become loss of self-control. And has had various justifications and rationales sought for it, but is often seen as what's termed a concession to human frailty, that somebody who wouldn't normally commit a murder finds themselves in a situation and things go too far. My interest in the topic, I've taught criminal law for several years, and it was actually a very clever question from a student last year. So we hear a lot about research-led teaching. This is sort of an exercise in teaching-led research. And I'll talk more about her question in a moment. And what seemed like a challenge thrown down by the Court of Appeal as well earlier this year, when they were talking about the third leg of self-control, which again I'll come to in a moment. And they said, we do not exclude the possibility of other circumstances where a disorder might be relevant to the third component, but none has been put before us. This suggests the question is of academic interest only. Well, hopefully it will be of interest to you this afternoon. I found myself getting completely engrossed in this topic now. So there's a couple of sections to the paper. First of all, I've identified 4 potential problems with the wording of the legislation, and then go on to look at how the defence actually does exclude what might be considered potentially sympathetic cases. I'll touch upon how medical evidence was used to, in terms of battered women syndrome, to advocate for women who were trying to use the provocation defence. But a shortcoming in the law in that, thus far, it doesn't seem other conditioned responses, our sort of instinctive mammalian responses to a threat or a trauma, are liable to fall within this defence. And I'm sort of concluding that the law does make concessions for people who've lost their temper, but there are instances where people have genuinely lost control on a sort of almost a primeval level, or due to having poor verbal skills, having experienced trauma, or just being physically or emotionally exhausted. And part of that, I'll argue, is to do with the quite political motivations behind the legislation and the way in which it was enacted. I'm obviously going to try and turn this into an article at some point, and one of the things, I realise there's quite a lot in that slide I've just given you. I'm not going to overrun my time, but one thing that might be helpful for me is if, in terms of writing it up as an article, if you think all the material should stay in the article, or if it's better just to focus on certain parts of it, and I'd appreciate your comments on that. So if we whip through loss of control, you have the statutory definition in your handout. It's unbelievably difficult to follow and quite clunky. So I've paraphrased a summary here for those of you who might not be familiar with it. The killing must have resulted from the accused's loss of self-control. Now that doesn't need to be a sudden loss of control, but it must be a temporary one. Sorry, this is also, it's a partial defence to murder only, it doesn't apply to any other offences. Now that loss of control experienced by the defendant must have had what's called a qualifying trigger. Either that the defendant feared serious violence from the victim against him or herself, or another identified person. The exclusion there is if the defendant has incited the fear of violence in order to provide an excuse for being violent in return. The loss of control must also be attributable to things said or done, or a combination of both, which constituted circumstances of an extremely grave character and caused the defendant to have a justifiable sense of being wronged. Again, unless the defendant has incited, the insults, and there's a specific exclusion of the discovery of sexual infidelity. That is not considered, or is specifically excluded from being a qualifying trigger. As I said, it's a slightly clunky defence, and the third limb of it is that a person of the defendant's sex and age with a normal degree of tolerance and self-restraint, and in the circumstances of the defendant, apart from those which only bear on the defendant's general capacity for tolerance or self-restraint, might have reacted in the same or a similar way to the accused. So when they say a camel is a horse designed by a committee, I think that has elements of this defence, because there's bits sort of shoehorned in there to meet various political objectives, which I will return to. Now, if any of those three limbs fail, then the judge does not have to leave the defence to the jury, unlike provocation, where it was a much more expansive test, and if there was any hint of provocation, the judge had to leave it to the jury. If any of those three limbs fail, then the judge does not. And the Court of Appeal has supported judges taking quite a restrictive approach on that. So that makes the wording of these sections particularly important. So if we start with what I think is the first potentially problematic area of the legislation, the loss of control must be attributable to the defendant's fear of serious violence from the victim against the defendant or another identified person. Well, it's not entirely clear what an identified person is. I mean, what if it's a bag of rags? Does it have to be a person known to the defendant or just recognisable as a person? It's not clear whether it would cover a fear of violence against a group of people. If, for example, somebody's making racist threats or religious comments, or a teacher I had at junior school, for example, who would beat one of the class seemingly at random. If it's not clear which child is going to get beaten, does the section kick in there? Given how much of a driving force behind the changes of the legislation was the desire to protect women in abusive relationships, or rather to allow them to use this defence, one thing that's not clear is what if an animal's being harmed? There's a lot of criminological research that suggests violence against pets is often a way into intrafamilial violence, and it's often a common feature, particularly if the partner who's being abused is very attached to the pet. So again, if you were to see your pet being violently treated or threatened, the defence wouldn't seem to cover that situation. It's also not clear if, well, it seems it's excluded if the threat isn't one of violence, but might be, for example, one of sexual assault. In the case of Sarah Thornton, which was one of the leading provocation cases, she was in fear of sexual violence the following day, which was part of her trigger. Or if the threat is of theft or something precious. So, for example, as lawyers, if we were to see the Magna Carta being attacked in Salisbury Cathedral, if we were to jump in and things went a bit too far, again, that would not seem to be covered by a loss of control defence. So that's the first problem. The second one is it must be the defendant who has the sense of being wronged. It's suggested in Blackstone's that a parent discovering their child has been abused, for example, the jury could find that the wrong done to the child was equally a wrong done to the parent. But there's no judicial authority to support that argument, and obviously that wouldn't protect any of those who weren't in such a close familial relationship. So again, returning to the example of the domestic abuse situation, if a child sees one of their siblings being humiliated, the defence wouldn't seem to be active there. If the defendant is their partner or somebody they're very close to is being racially abused, for example, again, the harm can't, or the sense of wrong can't be transferred from the other to the defendant. And again, the idea of perhaps somebody who is just outright outraged by somebody else being wronged. You may have seen in the news last week the case where some people put a firework in the pocket of somebody who was sleeping rough in Liverpool. Or if you see somebody who's being tormented by bullies, who's in a particularly vulnerable situation, a sense of outrage, of fury perhaps, would not be necessarily an irrational or an unreasonable response, but again would not fall under the protections of the Act. The third potential problem is that the trigger must be something said or done. Actually, Matt pointed me to this case in Stockport of a woman who killed her father and buried him in the garden, having discovered his rather extensive collection of pornographic images. Now, again, it's not clear whether that's anything said or done. Would downloading the images be sufficient? There's obviously a question of a time lag. He may have done that 15 years ago and not looked at them since, or is the time lag between the action or between the discovery? Again, that's not clear from the legislation. And also, what about something that's not done, which could be as enraging? So, for example, if your partner says they've paid the mortgage and hasn't, and you're at risk of losing your home, or somebody fails to turn up at the wedding, or doesn't bring the children for an access visit. Omissions, in many ways, can be as hurtful, as make you feel as wronged. But again, on the face of it, the statute would seem only to cover something said or done. Again, returning to the domestic violence theme, not giving a partner money, a sort of coercive control type situation, would perhaps be a factor there, but wouldn't be covered by the defence. And then part 4, it must constitute circumstances of an extremely grave character. Well, obviously you wouldn't want a defence to murder or a partial defence to murder to cover very trivial slights. But the second clause is slightly more problematic perhaps, which is causing the defendant to have a justifiable sense of being wronged. Now, the cases that have tested this so far haven't perhaps been the most sympathetic or strongest cases. Mianza killed the nurse in his psychiatric unit because she told him to turn his television down. But the judgment of the Court of Appeal was that the emphasis must be on the adjective justifiable. The appellant could have no justifiable grievance in relation to hospital and restriction orders that were lawfully imposed, nor in relation to the restrictions upon his relationship with his girlfriend, which we probably don't need to go into at this stage. Now, a lawfully imposed decision can lead to a sense of being wronged, particularly if it's not a correctly imposed decision. So somebody who, for example, is the victim of a miscarriage of justice, again, you may have seen in the papers this week, somebody left literally penniless by their universal credit, somebody who's being deported from this country, or who's been denied access to their children. All those situations can lead somebody to feeling very understandably wronged, but it's not clear certainly from the court's judgment in that case, that they would be able to use that in their defence. The justifiable sense was perhaps introduced to the legislation to stop cases such as honour killings, or so-called honour killings, more sort of controlling women's sexual behaviour. And the idea of tolerance is quite an odd thing to legislate for. I mean, is there a normative standard of tolerance? It was added as a separate additional criterion to the legislation, but it seems to exclude people who are bigoted or unacceptably intolerant in other ways. So, for example, excessive sexual jealousy, which is hard to argue against in many ways, but in terms of legislating, this partial defence is supposed to be there to mitigate an emotional failure that the defendant can't control. And it seems difficult to me if we're actually looking at the source of that emotion rather than the emotion as a category. So if it's accepted that an angry response is acceptable, it seems slightly more problematic then to say, well, it's only acceptable anger or the right kinds of anger that will fall within the parameters of this defence. Which sort of slightly brings us back to the vexed question of whether the test should be normative or objective in terms of the standards of self-control that are expected from the defendant. Now, that debate has gone on for many years, and the Court of Appeal has taken different approaches over time. But it does seem slightly illogical in that the court is acknowledging that an insult or a threat is experienced more deeply by the defendant, more deeply than other people would have experienced it, but then holds them to the same standard of conduct. And an idea I want to return to in a moment is it ignores the idea that that insult or threat is experienced in a wholly different way by some people to how the ordinary person would. And the last bit of this section is that there's very little scope for people who are just exhausted, or the circumstances they're in, who are in very desperate situations. And Doughty, the case of the man who killed his 17-day-old baby from, he says, exhaustion. And he said, it was reported in the Court of Appeal judgment, if my mind had been working normally under normal circumstances, there is no way that I would have done that. Exhaustion wouldn't be covered by the defences here. The baby obviously hasn't done anything to cause a fear of violence, or couldn't be considered an insult in any way. But in some ways, these seem to be the types of cases where you would expect the law to show some kind of mitigation, where somebody is acting in a way that is so out of character due to the sort of desperation of their circumstances. But Maria Eagle, who was the minister at the time taking the bill through, said, as far as we're concerned, it's not intended that that kind of case, unless it fits into diminished responsibility, ought to count as provocation. We're trying to put the bar higher and not to bring it down. But there was very little explanation as to why. This was an enormous, one of the new Labour compendious criminal justice bills that seemed to come through every year. And most of the parliamentary time was focused on the coroner's aspect of the bill, and actually not a huge amount of time was given to loss of control. But it seems to me people in many desperate situations, whether it's due to they're poverty-stricken or they're homeless or divorcing or being bullied, these kind of situations, whilst you instinctively you might feel they're the kind of situations that the law ought to be offering some concession to, would not fall within the defence, because in many ways the last straw may not be a qualifying trigger. If we move on to the psychiatric conditions or learning or communication difficulties, again, there's very little concession to those who are experiencing problems like that. They are held to the same normative test. And the Court of Appeal said last year, defendant is to be judged against the standard of person with a normal degree and not an abnormal degree of tolerance and self-restraint. If, and insofar as a personality disorder reduces the defendant's general capacity for tolerance or self-restraint, that would not be a relevant consideration. And again, you have people, for example, who have difficulty communicating. It's easier to understand how they may lose control and be violent if they're being taunted, because they don't have the same facility as a normal person to talk their way out of that kind of situation. And given how many defendants do have communication or processing difficulties, that seems potentially quite unfair. Right, this is the question my student came up with. she asked me about the play Death and the Maiden. And in that case, it was a post-conflict situation, presumably in South America, and the woman recognizes the voice of the man who'd raped her 20 years earlier when the military regime was in power. Or she thinks she recognizes his voice. He's changed a tire for her husband, and they're making pleasant chit-chat. And she says to her husband, "It's not only the voice I recognize, Geraldo, I also recognize the skin and the smell, Geraldo. I recognize his skin." And the implication there is she is very much back in the moment of what happened to her when he sexually assaulted her. But he poses no threat of violence to her now. He's sitting there making polite chit-chat with her husband, and he said nothing insulting. So the student's question to me was, could she use the loss of self-control defense? So I spent the whole weekend puzzling about this, eventually emailed a couple of colleagues who said, no, we don't think so. But it wasn't clear. So this is what sort of sparked my interest in the topic in particular. And some of the scientific developments, there was a lot of slightly dubious science maybe around the defense of provocation. This battered women's syndrome was developed, and the courts were very amenable to accepting that evidence. But it's not been used in the same way regarding loss of control. Now, this is a very noddy brain explanation, but our brains are broadly in three parts: the rational or thinking brain, the emotional or feeling brain, and our reptilian brain, which is the instinctive or dinosaur brain. And threats are dealt with. We go back to being animals if there's a sense of danger to our lives. So it's dealt with by the lower and midbrain, because obviously standing there philosophizing is not terribly useful if a mammoth is charging at you or something. So terror completely overwhelms the higher brain function. We don't have time to think about it. Your body just generally fight, flight, or whatever it thinks will prioritize your survival. The individual goes very much back to dependent on neural circuits that have evolved to provide adaptive defenses for more primitive vertebrates. Traumatic experiences, if they are unlocked, are more likely to be stored as implicit memories in your brain, which is a much more emotional response, sensory, so again going back to it's the smell, it's the voice I recognize. They're context-free, which means it's difficult for your brain to understand that was something that happened in the past. There's a merging of a previous threat and the current threat, and it's much more unconscious. So there's issues around autonomic reactivity, it's called, so how an organism responds on a completely physiological level rather than an intellectual one to a stress, an environmental stressor. So going back to the Death and the Maiden example, a very physical, visceral response to what's happened, no intellectual thought about, this isn't a dangerous situation now, completely overwhelming the rational processes. Now, obviously, if a defendant has post-traumatic stress disorder, they could use a defense of diminished responsibility. But many defendants may suffer some symptoms, but either not have enough symptoms to qualify for a diagnosis, or they haven't been assessed adequately. What's also interesting in many of these cases is they don't have overt symptoms most of the time. They would not consider themselves as having a post-traumatic disorder in any way, because they've dissociated from what happened to them. So again, a psychological technique of separating the self. But the parts of the brain that process a threat, so the amygdala and, I'm learning all these terms, secondary visual cortex, become very overactive when the traumatic memory is triggered. So the person feels as though they're experiencing something for the first time over and over again. So I had an email from a psychologist yesterday, which was hastily added in here, and his argument was, if the memory of a voice was stored as a sensory fragment in the brain with the original emotional content and the link to a threat to life, the individual may, or perhaps will, respond with a very primal or survival threat response, which is not consciously driven. So in summary, there's actually quite a lot in this I've thrown at you. There were many criticisms of the way in which the legislation was enacted. There were 2 Law Commission reports which weren't adopted directly, they were sort of tinkered around with. And some of those changes were very politically rather than evidence-based driven, or politically driven rather than evidence-based. And what's quite unusual, I think, is that it appears to have been drafted with a notion of who should benefit from the defence, which was battered women, and who should not, which was abusive men or men who found their wives had been cheating on them. Which is not a good way to make law. And I would argue there are still quite a lot of gaps within this new regime which don't always protect the people they were intending to, but just almost as a matter of principle, that's not how we should be legislating. So there have been omissions and a failure to protect some defendants. And in cases such as the death of the maiden, the law provides for those who've lost their temper, but perhaps not for those who have genuinely, physiologically lost control. And that's exacerbated by the restrictiveness of the defences of diminished responsibility and duress, and of course the mandatory life sentence for murder, which has driven so many of these debates and reforms. But that's another whole can of worms, which hopefully someone else can get into at a later seminar. Thank you very much.
Thought-provoking talk. I'm stepping in today for Jonathan as a respondent. He's thankfully recovering now. Unlike Jonathan, I'm not an expert in this exact area of law. My name's Roxana Willis. I'm a British Academy Postdoctoral Fellow in Criminology and a Junior Research Fellow in Law at University College, Oxford, which is just across the road. Can you hear me okay? Do that. So despite my legal background and interest in the insanity defence, over the years my research has become much more sociological in nature. I specialise in social class and socio-economic inequality, and I look at how this intersects with mental health. So Hannah has raised several interesting and critical points about the loss of self-controlled defence. Given my research area, I propose that these points are especially significant when we consider the experiences and perspectives of socio-economically disadvantaged groups. So I'd like to take this opportunity to build on Hannah's insights by sharing some of my own research findings. I'm currently writing a book based on my doctoral thesis. For this project, I conducted year-long observational fieldwork on my home council estate, which houses those among the most disadvantaged 10% of the British population. I look at how people on my estate informally handle conflict before matters are taken into the criminal justice system. I then assess what happens when the law takes over and the rules of the game change, quite significantly so. Part of this research involves me painting a picture of community life. This includes exploring the types of norms and values that are important to people on the estate, which I triangulate with wider research conducted in other geographical areas. So in the talk we've just heard, Hannah raises a valuable point about how widely Section 55(3) of the Coroners and Justice Act will be interpreted, which concerns the defendant's fear that serious violence will be used against an identified person. Hannah gives us good reason to ask, should identified person be widened to include unidentified persons within a group? Taking the perspectives of my research participants into account, and those similarly positioned, I would argue that yes, it very much should. One of my main research findings shows that people living on the sampled council estate attach great importance to community. This counters a dominant view that all sectors of English society consider themselves as free-floating individuals. In some areas, the centrality of the group is very much alive. Moreover, the group can be especially important for working-class children growing up in these very tough environments. Living on a council estate can form a central part of someone's identity. For those of us who are brought up on so-called sink estates, which are heavily stigmatised and demonised, solidarity with others is a vital part of survival, and it affords a crucial sense of belonging. Therefore, people in some socio-economically disadvantaged areas necessarily look out for one another, and they rely on each other for support. This leads me to another key issue Hannah raises. Should identified person include animals? There's a widespread norm in my home community that supports intervention when vulnerable life is being threatened or harmed. For example, if a child is being violently or sexually abused, if animals are being hurt, or if someone is being bullied and is outnumbered. Harms committed against vulnerable categories such as these are deemed especially repugnant and create a lot of anger in the community. Consequently, there have been several incidences where community members have responded directly to these harms themselves, sometimes with violence. On occasion, such responses receive backing and support from the wider community. For those on the estate, seeing violence threatened or inflicted against an animal, particularly a pet, may invoke strong feelings of distress that are on par with, or even greater than, seeing violence inflicted against a person who is less vulnerable and potentially able to defend themselves. Consequently, taking into account the perspective of some socio-economically disadvantaged communities in England, animals should absolutely be included in Section 55(3). And I'm sure many people from more privileged backgrounds would also agree with this. Moving on, Hannah's concern about the possible limitations of Section 55(4)(b) is another crucial point for us to address. This provision provides that the defendant is required to have a justifiable sense of being seriously wronged. Hannah notes that this might be limited to things directed at the defendant alone and exclude wider categories of people. For the reasons I've so far outlined, from the perspective of communities such as mine, it is sensible to conclude that D is wronged when the group is wronged. For those living in conditions of poverty, separating the individual from the group is not so clear-cut. People might be more interconnected, and so when someone in the group is being threatened, it can feel akin to an attack against the self. Hannah raises further concern about the notion of justifiable under Section 55(4)(b), but we might ask justifiable by whose standards? Hannah cites the case of Dawes, which tells us that justifiable will be an objective assessment made by the judge at the end of evidence. Is this fair? Will judges be able to comprehend the reasonableness of a defendant who reacts against harm inflicted on their community and/or vulnerable persons and animals? The objective standards applied by a judge will likely mirror more affluent experiences. However, research repeatedly finds that those who come into contact with the criminal justice system, both as offenders and as victims, come from areas of economic disadvantage. Therefore, the objective test for a justifiable sense of being wrong should at least consider what might be justifiable for those who experience conditions of economic necessity. This brings me to my final point. If we wish for criminal law to be more sensitive to the lived reality of vulnerable groups, then we could ask, is the defence of loss of self-control an improvement on the old law of provocation? Now, under the old law, the jury determined whether the conditions under which the defendant lost their self-control might have made a reasonable person act in the same way. To recap, the reasonable person test in criminal law, it's an objective test because it does not ask us to consider what the subject was thinking, but instead what a reasonable person might do. Following Camplin, the reasonable person test for provocation involved considering how a reasonable person with the defendant's age and sex might have responded in those circumstances. The controversial House of Lords decision in Smith widened the reasonable person test for provocation, so it could include any characteristic of the defendant. In Smith, this meant that the jury could take into account a severe depressive illness when considering how a reasonable person might respond. As we all know, Smith was widely criticised, and Attorney General for Jersey versus Holly, the Privy Council ruled it was wrongly decided. Instead, the Privy Council held that mental health characteristics should not be considered when applying a reasonable person test. The current law of loss of self-control, which replaced provocation, it affirms a narrow vision of the reasonable person test. Accordingly, only the defendant's age can now be considered, as is held in the statute. Could this be a step back? in terms of having a law that is sensitive to the stresses of growing up in tough socio-economic conditions. With a large majority of the prison population recorded as having one or more mental disorders, and the majority of the prison population also coming from the most socio-economically disadvantaged sectors of society, should we not strive to create more socially responsive criminal law where possible? So I very much appreciate the ideas Hannah has raised today, and as you can see, they've given me a lot to think about, and I think these points will greatly benefit from further discussion, which I now open the floor to.